There have been some recent developments in the area of Affordable Care Act reporting that we think are helpful for plan sponsors to understand. Just to reset ourselves here as far as who these reporting requirements apply to, they apply to applicable large employers as defined in the ACA. And that's generally defined as employers with 50 or more full-time employees, including full-time equivalent employees from the prior years. So those large employers are probably used to completing forms 1094C and 1095C annually to report on the type of coverage that you've provided to your full-time employees. What's changed recently is that since these filing requirements came into effect in 2015, there's been a good faith transition relief period that is applied with respect to these forms. And what that basically meant was that the IRS was not going to impose penalties if it could be shown that any mistakes or late filings were due to the good faith efforts on the part of the employer to complete the forms properly. That good faith transition relief has expired in 2020, meaning the forms for the 2021 year, which are being filed now in 2022, aren't subject to that good faith relief standard. So what does that mean for employers? First, employers should understand that there are pretty significant penalties for late or incorrect filings with respect to Form 1094C and 1095C. For larger employers, it's a $280 per return penalty with respect to the returns that are provided to employees, as well as the returns that are provided to the IRS. So you're talking generally $560 per employee, a penalty that could apply with respect to a late or incorrect filing. So that's a pretty significant penalty. There are caps that apply, but in any event, we want to try to avoid those penalties, obviously, to the extent we can. Now, one thing to understand is that there are reduced penalties if we do file late or if we have an incorrect filing, if we make corrections within 30 days. If we do that, then the penalty can be reduced to $50 per return. And if we correct by August 1st, it can be reduced to $110 per return. So something to keep in mind of if we understand that we did make incorrect filings, that we do have some period after the filings are due to make corrections in order to avoid those larger penalties. So this year, I think in particular, we should be really cognizant of if we get any responses based on our 1094C and 1095C filings, that the IRS may be looking at these with some more scrutiny. As far as the development that may be on the more positive end, the IRS recently issued proposed regulations that we expect to be finalized and can be relied on in 2022 that changes the filing deadline with respect to 1095C reports that need to be provided to employees from January 31st to March 2nd. Now, annually, we have gotten a notice from the IRS that made this same extension, but this regulation really just makes it permanent. So we should be seeing that in the future, that we don't have to get these forms done by January 31st, and that'll be codified in the regulations. And we expect, again, those to be finalized. As far as takeaways from these changes, I think one is to make sure you understand your status as an applicable large employer. One trap for the unwary is if you have a small employer itself, but you have a number of related employers. There's a concept called a controlled group, and if those related employers are sufficiently related under those IRS rules, the employees will be aggregated to determine whether that 50 full-time employee threshold has been passed. So really want to understand whether you're subject to these requirements at all. And if you're a smaller employer, make sure that you're taking into account those employees of your related employers. Obviously, we want to make sure that we're filing these forms accurately to the extent that we can, because the IRS is going to have a little bit more scrutiny with respect to them. If you're unsure about how to complete them, certainly reach out to your advisors, either us at Bond or other advisors you may be using, because again, going in the future, we want to make sure that we're filing these accurately because the potential for penalties have increased. If you have any questions, please call your Bond attorney or reach out to me or any member of the Employee Benefits Practice Group. Thank you.